Science Sequoia sponsor. Google and Bloomberg Engineering is our Redwood sponsors. CodeThink for Douglas Fir. Our coffee sponsor is Altus Metrum, very important. And Versity is also a sponsor. And we want to especially thank JMP and Altus Metrum for reducing the proprietary use of code in their software. Tomorrow, as you've seen on the schedule, is our unconference in the afternoon and lightning talks in the morning. There's 2 slots left for lightning talks if you want to get in on that. If you're interested in hosting an unconference discussion, there's a sign-up board next to the registration desk. Or if you're not interested in hosting, you can check out what's out there and just add a little dot to the ones you're interested in. And we'll be making that schedule later today so you can plan your day out tomorrow. You can also purchase an OpenWRT1 at the registration desk for $128. We take cash or card for that. There's 1 water bottle in the Lost and Found. If you're missing that, talk to someone. Tomorrow, if you're traveling, we are going to have a place where you can store your luggage. You can check it at the registration desk and then pick it up at the end of the day so you don't have to go back to your hotel and grab that at the end of the day. We have 1 cancellation on the schedule. Arti Ramkrishna who was doing Belonging in the Pipeline, Building Inclusive Futures in FOSS, will not be able to make it today. So we're sorry. Hopefully she can give that talk next year. And today I'd like to introduce our keynote. We have Allison, who is the board chair of SFC, who's going to be talking to our SFC team about the Visio case, which is coming up in September. So if you'd welcome them to the stage.
Tracy, I need to ask your permission to be on this panel. I didn't bring my badge. Today I forgot it. Am I allowed to be on the panel?
Can you show me some ID?
No.
Yeah, fine. Hi, everyone.
It should be green.
I think it's on.
Hello, everyone. So this is a Q&A. We're going to start with a quick round of intros and some background information, but there will be someone wandering around the audience with a microphone, so be ready for questions once we're done with the intro. So get started. Allison Randall, board chair of Software Freedom Conservancy. We're just going to run down the line and do...
Back so you can see us.
Run down the line, quick intro.
I have to introduce myself.
You do.
So I'm Bradley Kuhn. I've worked on copyleft and GPL compliance and enforcement since 1999, and I have worked on multiple lawsuits related to the GPL, and mostly GPL v2. And you may remember there was a very large case in the early 2000s of Software Freedom Conservancy and Eric Anderson versus Best Buy et al., which was 14 different defendants. That was a copyright case. And what we're going to hear about today is a case that's not a copyright case.
So I'm Denver Gingrich. I am currently the Director of Compliance at Software Freedom Conservancy. I've worked at Conservancy since 2011. I actually chatted with Bradley very early on about this this Blu-ray player that I had, which was made by Insignia, Best Buy's store brand, and so that's one way I got connected with all of this. And yeah, I think it's just really great that we can work together to make sure that everyone is getting their software right to repair.
And I'm Rick Sanders, and I am General Counsel for Software Freedom Conservancy. And before that, I had my own firm, and so I was actually outside counsel for SFC when the Visio case got started. So I've been with the Visio case from the beginning, both as outside and inside counsel.
Great. So to start on our background, Denver, why don't you tell us a little bit about the compliance process and how it works?
Sure. So what we're trying to do with compliance is we are giving people the rights that they have under these right to repair agreements that we have. So the GPL and LGPL are designed to give you the practical ability to modify and reinstall software onto the devices that you have. And so this is a thing that's been thought of for decades, and I'm glad we have it codified into some agreements that we use. And so when I started in free and open source software, I was very excited about this idea that we could all do this. And then I saw that Linux was being used increasingly on lots of different devices, and I thought, this is great. Now people will get more and more freedom as more and more devices use Linux. And then I discovered, as partly through this Blu-ray player that I had, that actually I wasn't getting the freedom everywhere that I wanted to, and that the agreements that required that I have this freedom. So companies choose to use Linux in their products and other free and open source software, and that's great. We're very happy that they've chosen to do that, and the only condition is that you give everyone the rights that you had, that were given to you. So, for example, when Best Buy uses Linux on their Blu-ray player, they have the ability to install it, to modify it before they install it onto their Blu-ray player. Then when they sell that player to you, then they have to give you those rights to modify and install Linux onto that player. And so I was very excited that we could do this, that we could get these rights for people. But I realized that to do this, there's a lot of work that needs to be done. And so anyway, this is a long-winded way of saying that the way we do this is we receive reports from, I guess, people like me who see that their devices use Linux and other free and open source software. And then we'll take a look. We'll see, what software is being used, and whether there's an offer for source code or source code along with the device. And then we'll go through a few different steps to see if we can find that. And then if there's an issue, then we contact the company. And so oftentimes what will happen is the company will send us back something, but it is very rarely, unfortunately, complete corresponding source code. And that's really unfortunate, because if you don't have complete corresponding source code, then we cannot get those rights that the agreements, these software right to repair agreements like GPL v2, LGPL v2.1, et cetera, grant us. And so I received these reports, do all of this work, and Visio is an example where we received a report. We did some research, and then we came back to it after a few years to see if things had changed, and they sadly had not. And so this is the general process that we use, and it's really unfortunate when we can't get back to someone in a few months and say, hey, we solved this problem, because unfortunately sometimes lawsuits are required, and lawsuits can sometimes take a while, which we'll probably talk about a little bit here today. So yeah, that's a general overview, and I'm of course, in addition to I'm sure the Visio specific questions you have, happy to chat a little bit more about some of this process as well.
I have a very quick follow-up for Denver. So would you say, all these years later, that your Insignia DVD player was in fact not a Best Buy?
Wow. I wasn't expecting to respond to questions of that nature.
Too early in the morning for that kind of fun. All right, so Bradley, why don't you tell us a little bit how this particular case got started?
So as Denver mentioned, he had worked we call this is a kind of a legalistic term, working the matter of the Visio violation, and we rarely sue anyone because we like to work collaboratively with people and convince them that it's in their best interest to follow the license, which we truly believe it is in the best interest of everyone in the industry because it makes better software, 100 different reasons. So Denver had worked that matter, as he mentioned, in late 2018 into 2019. They never really were fully responsive. Eventually, they just stopped answering emails. So while Denver was on family leave when his daughter was born, I said, well, Denver's out. I should check in on Vizio. And I was thinking, so it was right around the time. So this is like right in the middle of the pandemic, and everybody's pushing me to be on video chat, which I hate, because I had designed my entire work from home life around the idea that I could do all housework during conference calls. And you can't do that on video chat so easily if they expect you to show up. So I was like, well, how can I be on video chat and fold laundry at the same time? I said, you know what, if I had like a BBB client mounted on the wall, I could just be here folding laundry and doing a video chat. So I was thinking, well, one of these so-called smart TVs, that might work out really well. So we bought some Vizio TVs, and there didn't appear to be an offer for source code. And so I started investigating it more. There's some folks here, I don't want to actually name them because I didn't ask them if I could name them, but there are some folks here who helped me take the TVs apart. I said, so my first thought, but actually we always assume the best. My first thought was, and this does happen sometimes, Vizio decided after the back and forth with Denver, they weren't going to use GPL software anymore. They were using VxWorks or something, right? So we assumed that maybe that's why. That would make sense. So we took, but I wanted to confirm. So we took the TVs apart. We hooked up to the serial port. We found it on the board, and we booted up, and Linux boot screen comes flying by. So we were pretty sure it was running Linux at that point. It would be very funny if they switched to VxWorks and then it like booted, but printed Linux boot messages. So we figured, and then eventually we were able to extract the file system, look into the details, and of course we found clear evidence that there was copylefted software. And in the meantime, we had been working with Rick quite a bit, talking about what the best way to, and best legal theory to enforce the GPL was. And Rick he has claimed correctly he is the architect of this case and really thought through the best way to do this and designed the case. And that's how we got started.
So Rick, following on from that, why don't you tell us a little bit about the idea of third-party beneficiary and the legal grounding behind that?
All right. And also, when this case was getting started, a lot of these legal theories were developed with the aid of Pam Chestek. Well, so let's ask a question. Have any of y'all ever downloaded some GPL license software in executory form? Okay. And did you think that if you asked for it, you could get the source code? I mean, would you go so far as to say you have a right to it? Yeah. So that's the kind of common sense legal theory here, that you have that right, you should be able to enforce it. And so the idea here then is to come up with legal theories where the recipient of the software can enforce the GPL's agreements without needing anybody else's help. And that the result is not money, but the result is the complete and corresponding source code. So we have one main theory and some other theories. And the main theory works on the fact that, well, first of all, it presupposes that the GPL are contracts, which has not been actually controverted in the case. But that doesn't solve the problem, because it's a contract between the licensor and each of the downstream licensees, and you, so you might have a contractual relationship with the licensors, but you do not have one with the party that you got the software from. So we need another way of looking at it. And the way we look at it is to say that, well, you are pretty obviously an intended beneficiary of these contracts. And this is a fairly common I mean, it's a kind of contract theory that you learn first year of law school. A good example would be something like I owe Bradley money, and Denver owes me money. So I say to Denver, let's do a contract, let's cut out the middleman. When it comes time for you to pay Bradley. There's a contract between me and Denver. Bradley's not actually part of that arrangement, but he's clearly an intended beneficiary, and the law says that if Denver were to welch, he would. You know, I knew I should have used different people.
That's why I volunteered.
But you know, it's actually such a terrible hypothetical because Denver never would do this. But if Denver were to welch, Bradley would actually be able to sue Denver under the theory of third-party beneficiary. So we say that recipients of the software are the intended beneficiaries of the GPL agreements. And for evidence, we point to two places. The preamble pretty clearly says, make sure that you too can get the source code, that you, the recipient of the software, can get the source code. And then Section 3 itself specifies that third parties have this right, a written offer to give any third party the complete corresponding source code. So it's a pretty straightforward legal theory. And we do actually have there's some other legal theories out there that actually don't require the GPLs to be contracts, but I can get into those if there's enough interest.
Yeah, so it looks like we got a hand for the first question. Who has the microphone?
I think John does.
John does. Nope.
John has a pen.
Yeah. Does somebody have a microphone?
Yeah. Do you mind going? The Signal folks have it. The Signal folks have another one, I think. There. Urban Signal. Sorry, I said Signal. They have another one there for you, I think, to run. Well, he's getting to the first question. Rick, can you talk a little bit about this? Because most people in this audience are probably pretty familiar with the GPL and the copyright case we did. Can you just briefly describe how that copyright and how GPL is both a copyright license and a contract at the same time?
Oh, sure. Well, okay. So, you know, what's a license? A license is permission to do something. It actually goes back to days when you can give people permission to go onto your land and do things like, you know, chop down trees or gather fruit or something. And so it's a permission, and then so I can give you a license to do something, and then I can get maybe money from you or something in return. So the license in that situation is just a term of a contract. I'm giving you something, a license, and then you give me something in return. With the GPL, you're getting a license from the original licensor, and in return, you are making a solemn promise to give to any people who ask the source code, and that's enough.
So it was the colorful T-shirt here was the first 2-3 rows in front of you was.
To be clear, it's not a binary. It's not a binary. It's both, and it's I've been working in the copyright field for a long time.
You got to be careful telling this audience something's not binary because they're all geeks. Everything's stored in binary from their point of view.
Not dichotomous.
Yes, there we go.
All right, first question. Thank you.
So I was just interested in the other legal theories. That's why I raised my hand when you asked that question.
Okay. All right. So one legal theory that doesn't require it to be a contract is simply take that. it's a written offer. It says in the GPL, written offer, and take it literally. A contract is an offer that is accepted and has what is called consideration on both sides. So both sides either get something or have to do something, both sides. So we just take it literally and say, written offer. You call up and say, or whatever, you call up and say, I'd like the software, please, or I'd like the source code, please. We think at that point, a separate contract has been formed. Now you do have a contractual relationship with that downstream licensee. So that's number one. Number two is, I might be getting in the weeds a little bit, so let me know, is something called promissory estoppel, which is if I say to you, you can travel to New York this week, and I'll pay your expenses. And you do. You go off and you go to New York. You spend all your money, and I say, okay. And you say, well, Mr. Sanders, please reimburse me. And I say, screw you. So, well, that's really unfair. And so, because I made a promise and you relied on it, there is a theory, what we call an equitable theory. And equitable just means for the sake of fairness, right? We're not going to stand on legalisms here, just for the sake of fairness. We're going to make me liable for, to make you whole and pay the money I promised. And again, there's definitely a promise in the GPL. And then if people were to say get the software with the expectation and relying, they buy say a TV with the with the idea that they will get the source code and maybe tinker with it or something, then I think that's reliance.
Next question.
So having ground my way through all the filings and things like that, and a happy afternoon.
Oh, I'm so sorry.
I appreciate the sympathy. What do can you talk to what you think Vizio's litigation strategy is here? Because it seemed like they had one big idea, which was remove it to federal court, try it as a copyright case, and when that didn't work, they sort of then, in their motion to dismiss, said, well, that Dummel district court judge got it wrong, which doesn't seem like a winning position in front of a state court. So that's the question. So
their main legal theory so far, right? Well, the first one is something called preemption. Okay, and preemption is where federal law knocks out state law. And it only happens every once in a while, but copyright's one of them. I mean, copyright has a very strong preemption clause. I think it was pretty clear that this one was not preemption. I think that was always kind of a long shot on their part. But if they were to succeed, then our contract claim would go away. They didn't, and that's also why it got removed to federal court, because copyright can only be heard in federal courts. So now that we're back and we've knocked preemption out, that defense, it's now out of the case. It could come back up and appeal, but right now it will not come up at trial. So now their new, what they've really been focusing on is when you're trying to prove third-party beneficiary, one of the things you have to prove is that letting third parties enforce it is within the party's reasonable expectations. And so they've been trying to argue that because of things that others have said, that the idea that a third party could enforce their right to the source code would be just completely shocking. I have all kinds of problems with this. First of all, I just don't think that's what that element means. I think the element is more of a common sense element and not some kind of, let's take a poll about what everybody felt in 2005. But so that's been what they've been really focusing on.
Yeah, and
that's how the FSF got subpoenaed.
Yeah, and to give, I just before we jump else, if I can give kind of the, Rick gave the lawyer's answer, I'll give the plaintiff's answer, the non-lawyer answer to your question about strategy. I think one of their obvious strategies is delay. They're trying lots of things to delay. It's why we filed this in 2021, and we're just coming to trial here at the end of 2025. And the copyright preemption thing, I felt it was bad form because, as you point out, to have a federal judge decide something, go back to the state judge. Removal is standard, right? My favorite copyright removal case is actually Jello Biafra versus the other members of the dead Kennedys. They sued him for royalties. Very similar situation. It was a copyright. They also had a contract that he was supposed to pay them a part of the royalties. He was running the record company. There was an argument, and obviously, Jello's attorneys tried to remove it to federal court, and it got remanded. Pretty standard. But the fact that they kept coming with different ways to raise preemption was just, in my mind, a delay tactic. And to just put a finer point on the stuff other people have said, if you've read the filings, you'll see they have, I now know everything in my entire life that was ever recorded or written that I ever said about the GPL, because they read it all, and they're trying, and you people have all seen me speak, right? I say lots of stuff. I don't know what I'm talking about necessarily, right? And it shouldn't be required that I always have to be right every time. And they found a place or two where I said something not perfectly, and they say this is evidence of something. But of course it isn't.
So two-parter. So are you trying to make precedent here of a new theory that other people could use moving forwards? And secondly, do you think this will work in other jurisdictions, say not non-American?
I mean, I can maybe talk about that briefly. Last year, there was a lawsuit that concluded in Germany that we funded that was similar in the sense that it was a contract claim, and that one did resolve with the company providing the scripts used to control compilation and installation of the library in this case. And so, this sort of thing has been done elsewhere in the world, on contract, and seems to be working pretty well, given that example at least. So yeah, I hope, we can make this a more common thing to do in the US. I mean, not that I want to have more lawsuits, but given, my experience with all of the reports that I get, I would say we probably have to do, a few more at least.
But,
Yeah.
But,
Go ahead. Go.
Okay. But, I mean, a limitation of this approach is that it relies on state law. And the nice thing about copyright law, it's the same throughout the whole United States. Furthermore, because of various treaties, it's kind of similar around the world. So contract law can be a little different here and there. And we're under California law, which is sometimes its own thing. So that is a kind of limitation that we just have to live with.
Yeah, and the other point I wanted to make about around the world is most of you are probably aware, but maybe a few are not, that there has been a tremendous amount of GPL enforcement in the courts in Germany. Howard Welter did a wonderful series of cases in the early 2000s over his copyrights in NetFilter. We funded Christoph Hellwig's lawsuit against VMware. But for those of you that don't know, the legal systems in Europe are usually civil law systems, and they're not precedential. So all those great cases where Howard got success and so forth, they don't make precedent at all. You just have to bring a new case. And the other really nice thing, I think, and people actually, not that we don't have that many international attendees because of the world today, but except for you, but you'll roll your eyes, but everybody else in the U.S. maybe won't. There is a real value to the U.S. legal system. It is grueling. Because there's this whole discovery process, which I'm going to talk a little bit more about in a few minutes, and all this sort of thing that doesn't exist in Europe. But if you look at the VMware decision, I read that and I was like, darn, if we had done discovery, we would have had a much better decision, because there's this place in the decision where the judges basically say they couldn't figure out how to get software off of a CD-ROM. I am not kidding you. And so, like, this is the kind of thing discovery solves, right? The software is well off the CD-ROM, been examined by both sides, presented to the judge by the time the judges are involved here in the U.S. So discovery is painful, but it is a search for the truth, and that's a valuable thing in the U.S. legal system that I'm glad as much as we've done this. I guess I'm probably the only one here who likes discovery, so maybe that's.
I've been doing discovery my whole career, and I hate it. God, I hate it. And just highly technical. At a minimum, we're trailblazing. Whether this becomes precedent will depend on whether there's an appeal. So.
Other questions? Yeah? Got another one over here.
Thank you. So one other thing I noticed in grinding through the filings is it didn't seem like Vizio at any point said, by the way, we never violated the GPL, full stop. That they never seem to actually assert that anywhere. And first of all, question one is that my understanding there correct? And second of all, was this perhaps an attempt on their part to limit discovery so they don't have they don't have people groveling through their proprietary code?
No, if anything, they have done quite a lot to expand the scope of discovery. They, because they're big, they can take chances. Like the preemption thing was maybe a 25% chance, but a small party can't risk it. But Vizio's got the money to, if it's a home run, it's worth taking a swing. So if anything, they've been expanding discovery, particularly with all these third-party depositions they've been taking.
I think the thing I'd add to that is in the copyright route, like we did in the big busy box case, the importance for the other side to swear up and down they never violated is stronger, because the main thing we were always going for in the copyright cases was the termination clause to basically restrict their right under copyright to continue to distribute the software and ideally get a preliminary injunction towards that. Obviously, Rick could tell me if I'm wrong, but I don't think there's any way to get a preliminary injunction over third-party beneficiary. It doesn't seem like that would really be possible anyway. So there's kind of no need to have that argument about that issue.
That's true. So preliminary injunction is an injunction at the beginning of the case that maintains the status quo, so that by the time the plaintiff gets the relief that they're entitled to, assuming they win, they don't go out of business or some awful thing doesn't happen that could have been prevented. But it's always put in terms of what the other side can't do and maintaining the status quo. So we were actually asking for a change in status quo. Please give us the source code. So we would not have been entitled to one.
And another standard tactic in the copyright side, which just doesn't exist here, which is why there's these kinds of differences, is in the copyright cases, we filed and said, we hold copyrights. We don't think you have a license. And they argue the GPL back to you. So they say, no, we do have a license. Here it is. It's the GPL. And we say, oh, that license. We know that one. Yes, we put it under that, but you didn't comply with it. So the copyright case kind of starts that way, which of course doesn't happen here.
Could you tell me what discovery is?
You're going to be so sorry you asked that.
Discovery is a ton of fun. But I'll let Rick say why it's not first.
So in the American system, and I think I think we kind of turbocharge it, but there's something similar in other so-called common law systems, so Britain, Canada, Australia, New Zealand. We kind of let the parties go into the playground and kind of beat themselves up a little bit without a lot of parental supervision. And discovery is where I discover information that will help my case. And it's broader than what can be put into trial. So what's admissible at trial is one thing. Discovery is much broader. The idea is that you're creating a universe of documents and testimony, and from which, when trial comes around, you'll pick out the bits that make your case. And when I put it like that, it sounds so like it makes perfect sense. We're just trying to find out stuff, So I can write written questions to you, and you have to give me written answers back, for example, or I can depose, that is, put you in a room with a court reporter, put you under oath, and I ask you questions all day, which is like going to the dentist for 7 hours, but your teeth aren't clean after that. But the process is just, it just causes a lot of fights, and it's time consuming. It costs a lot of money, and it's the main reason why the American civil legal system is so unbalanced, because big companies can manage this a lot better than little guys.
Yeah, I mean,
Did that answer your question pretty generally? I can get into more detail.
Yeah, I want to make the case for why discovery is great. I do agree completely that the expense of it is a difficulty, especially for a small organization like SFC. The really interesting part of it is, I mean, maybe I'm just like, because I'm not a lawyer, I naively believe in truth and justice from the courts, but I like the idea that there is this universe you create, right? There's the universe of the facts of the case, and discovery is trying to discover all those facts so that both sides can have their fair shake in front of the judge to make what the arguments are and have those facts in front of them. And I think depositions are fascinating. I don't think it's anything like going to the dentist at all, although I don't really mind the dentist. But the interesting thing about depositions is, as Rick said, it's lots of stuff that's probably not even admissible at court. And there's a tremendous amount of leeway of the kinds of questions you can be asked. And I have actually brought, so during one of the breaks, I'm going to be in here, I'm going to have them, we're actually going to release some of the deposition transcripts. I have mine and one other one with me today printed out. And it's really fascinating when you start paging through and like the kinds of questions they ask me. It's kind of bizarre, the stuff they ask me, like about my relationship with Richard Stallman, those kinds of things. And so I find it interesting, and you just find out all sorts of stuff, and most of it's all public documents. Some of my depositions, many of the depositions were marked confidential or attorney's eyes only, but those are only small parts of it. And so there's lots of interesting stuff, and we're going to publish a lot of it. I mean, if you like reading somebody being asked and answered questions, but I'm telling you, it's a lot of fun.
Any other questions? Yep.
We were just to look behind the curtain. We were debating how many people in the audience had read the entire docket, and we knew that whoever it was or whoever they were going to ask lots of questions. So we were ready for you.
Well, first of all, this is the awful, not a question but a comment, which is thank you for your good work. This is I'm glad people are taking the lead on enforcing the GPL, because without that, why bother? And my Civ Pro professor used to, when asked what discovery was, he said, well, in federal courts, usually about $50,000 to $125,000 was his comment. So, but the actual question is, suppose, hypothetically, let's say it's not Vizio, let's say it's Oppo or somebody else, came back to you with, absolutely, we comply 100% with the GPL. Here's your brand new shiny install Gen 2 disk, thunk, and the driver we use for the display. Oh, you want the stuff that actually runs the DVD player? Oh, that's all userland stuff, and it's under the LGPL, and you don't get it, sorry. Would that have an effect blocked the kind of case that you're bringing?
Yeah, I can speak to that. I mean, we're asking for the complete source code for the programs under in this specific case, the programs under the GPL v2 and LGPL v2.1. So, I mean, kind of going back to what I was saying earlier, we need to have all the rights that Vizio did per the license. This is what it says in the preamble. It says, all the rights that you have are what you need to pass on to those you distribute to. And so I mean, if we can reinstall these programs onto the device that we got, and we can make practical use of the source code to make changes and modifications, if the proprietary things that are not, and by proprietary, I mean not in any way subject, like, however the lawyers determine they are not under the under the GPL, if those don't run or otherwise are non-functional, and they're not combined with an LGPL work, since there are certain rules for that, then that's fine. Like we just want all of the things that we legitimately have the right to complete corresponding source code for to work, and for us to be able to modify them and for them to be able to continue to work. And I mean, that's what's happened historically. Like when you think about OpenWRT, like we didn't get the source code for all the proprietary things on that initial router, which started OpenWRT, which is fine. There were lots of people in the community that wanted to write those things. So things like the Lucy web interface and these sorts of things. The community comes together and they build that.
Yeah. I'm sorry to interrupt you. I was just going to, and indeed, but when the first OpenWRT release, it didn't have a web UI to configure the router because the Linksys web UI that was on the WRT54G was indeed one of these proprietary applications. We never expected when we did the OpenWRT or the WRT54G enforcement that we would get that. We believe that it is possible to run a legitimately, I'm using legitimately in quotes because I don't think any proprietary software is ethically legitimate, but a legally legitimate proprietary program. And what we've been trying to do is, for years at this point, is to create another OpenWRT community. We're very public about this. I would really love to see, I'd really just love for Visio to give us the complete corresponding source code, including the scripts used to control compilation, installation, and executable, and we'll start a community of an alternative firmware that does other things, like run my video chats or video chat client on the Visio TVs. I think it makes the hardware more useful. I think it makes it not fall to obsolescence as quickly, and lots of other reasons why this is just better for the world if they just comply with the license, and I don't care about their proprietary stuff.
I'm going to break my moderator role and answer the second half of your question, which is, you've probably read it. There's a document that Bradley and Karen and John there, who's handing out the microphone, drafted years ago, the principles of GPL compliance. And the goal of compliance litigation or compliance action is always compliance. So if you have compliance, then yes, absolutely, there's no case. You never need to go to litigation. Like, that is not the point. The point is compliance.
So you mentioned this as a somewhat novel legal theory to go after this as a contract instead of as a copyright case. Is there a potential for someone to try a different case in a different jurisdiction under a different theory that could potentially derail or delegitimize your approach?
While Rick's thinking, I want to point out, this is not a novel legal theory. The thing that's historic and novel is using this legal theory for GPL enforcement.
I mean, somebody could, try the preemption route. I mean, I think that would be, and that route has already been, laid out by Visio in this case. I'm not too worried about it, but that would, and that might, create a split where, in one part of the country we have it one way, and in another part of the country we have another way. It'd be a weird split because it would be a split that the Supreme Court could not resolve. Because if it's not preempted, then it belongs in state court.
Yeah, and I mean, this is, you'll see this in the filings. And in my deposition, the Williams, this lawyer from the big fancy Quinn Emanuel law firm that represents Visio, was asking me over and over again, well, don't you think that millions and millions and millions of people all over the country who bought Visio TVs are all going to sue us, and wouldn't that destroy the entire industry? It's just a bizarre argument, because it is a lot of work to bring a lawsuit. It is a lot of effort, a lot of financial resources. There is no attorneys. Despite Larry Rosen's many efforts, there is no attorney's fees clause in the GPL. You have to pay your own attorneys to do this. So while I do think people could bring other cases and people should adjudicate their rights, I think it's quite an undertaking to go do a lawsuit. I don't think we're good. Well, I mean, everybody looks at the U.S. and says, you're such a litigious society, but we're kind of not, in my opinion.
I mean, to me, I look at that statement, and to be clear, this is not exactly what's being said, but it feels to me like like what's being said, is. If we violate the GPL, like millions of people could ask for their rights, and it's like, they could. That's true. There's a way to solve that.
Yeah, I mean, right. It's like if you build a car that as soon as you drive it off the lot, the wheels fall off of it. People be like, but we have a right to build a car that the wheels fall off of. Millions of people could sue us because their car didn't work when they drove off the lot. Like, how? That's horrible. Well, they should sue you. Like, wheels fell off as soon as they drove it off the lot.
Any other questions?
It's not questions so much, but I'm just struggling to work through, like, say Vizio, gave you the complete corresponding source in this case, and then, you drop the lawsuit because you've got what you want. It just seems a shame that, 4 years of effort has gone into this, and then there's no legal precedent established, or, and then say they go back to, their next model, they go back to violating the GPL. Do you need another 4-year journey to get the same thing?
I understand the concern. I'll let Rick in a minute just talk about the kind of legal aspects of that. But as far as the policy aspects of that, this is impact litigation. It's designed to create and set public policy. It takes a very long time. If you think about other impact litigation in the world, like the Bergerfeld case and those sorts of things, they take a very long time to get there, but things start changing while we're getting there. I have lawyers, even at this conference, come up to me and say, I want you to win this case because as soon as you win it, regardless of whether it's appealed or not, they feel it will give them power when they're talking to clients who say, I don't really want to comply with the GPL. They say, look, you got to do it. And I was told that nonstop in the 6 months after the BusyBox case, where people said, oh, you made it so much easier for me inside my company because you, and we didn't even get we got one judgment in the BusyBox case against one defendant, but generally they settled. But the fact that we had settled and gotten all these companies, not all, only 14 companies into compliance with the GPL, it changed the industry. And we are going to change the industry again when we win Vizio.
And I would just, what you say is true. Since we're asking for specific performance, we're not asking for money. We're just asking for the complete corresponding code. If the Vizio were to comply, then we'd have no more performance to specify. I would say that the next time will go a lot more smoothly. I think we've learned a lot, and I don't think, and I think not just us, but anybody who talks to me or reads the filings, I think it'll go a lot more smoothly next time.
I think we only have 3 more minutes left. Is that right? Yeah. So thank you for your questions. Feel free to catch us afterwards. Do you all want to do a quick closing thought?
Sure. First, I want to say all of us are here, I think, through Sunday, and we're going to be around. Later today, during the breaks and stuff, I'll be sitting around here with the printouts of the depositions I brought. If you're curious to look at them, we can look at them together and chat about that kind of stuff. And that's the kind of stuff we're going to be releasing. Please watch our website and watch for the information. We're going to be doing a lot of publishing over the next 6 to 8 weeks as we get towards and into trial. Just lots of materials and interesting stuff about the case and what it means and what's coming up. And also, court proceedings are public. If you're interested in going to Orange County for a week and hang out, I'm telling you, there's a reason why the television programs about lawsuits are very popular. They're dramatic by nature, and it's going to be an interesting thing to watch. And there may be a way, sadly, with proprietary software, but it's fortunately Zoom for Government, which has much better terms than the regular Zoom, even though it's still proprietary. So you might be able to, we think you might be able to watch it online, but we're actually kind of worried there are so many people interested that the Zoom for Government might crash because they're not used to lots and lots of people showing up. So if you can come, you can come. We have a thing on our website about you can apply for. We're gonna if you're somebody who likes to write online about stuff and have experience, even just a little bit of experience doing that, you can apply for a travel grant to come and attend the trial. So that's on our website. The initial deadline passed, but it's rolling. So you can apply now and possibly get a travel grant to come. And I think that's everything I would add.
Yeah, I'll just reiterate that. I mean, I think it has been rolling by on the screen, probably behind us occasionally, but yeah, September 22nd in Santa Ana, California. If you want to be there, that would be great. I think, it's pretty compelling. I mean, at least to me, when there are a lot of people sitting in the courtroom that care about what's going on. So yeah, if you want to do that, definitely check that out. And yeah, I think this is. I'm excited to see so many people here interested about this. I know, lawsuits can be kind of dry sometimes, but, as you've learned, discovery is very exciting and fun. And so there are a lot of the parts of the case that are very interesting, to different people in different ways. And to me, I'm just so excited to get our software right to repair and modify and redistribute and share. I mean, that was the great thing about the early days of software is everyone was sharing with everyone else. They were all installing it on the computers that they had access to. And I want us to get back to that, where we can all do that. We can all help each other out. We can all make our computers do what we want and need them to do for us.
Oh, well, my final thought is it's been a wild ride so far, and thank you all for y'all's support.
Thanks to our panelists. Thanks, everybody. Go get some coffee.